Let's walk out with her though. Let's do that first. We can fill in that long note as needed. Okay.
Is there an earthquake? Is there an earthquake somewhere?
through this one, but then I realized I wrote on it. Oh, there's two people. Please rise. Circuit Court for Deschutes County is now in session. The Honorable Alicia Harriet presiding. Good morning. Please be seated. All right, we are on the record in 23 CV 49245. I have Mr. Thompson and Ms. Thompson in person. Good morning to you both.
Good morning, Your Honor.
And do I have Mr. Steele?
Yes, Your Honor, I'm appearing by video today.
All right, thank you. Good morning, Mr. Steele.
Good morning to you.
We are here, thank you. We are here on a number of matters this morning. We are here on plaintiff's motion to set aside, as well as the objection to attorney fees. And I have reviewed the filings and the responses to each of those matters. It is the court's intention to hear argument today on both take the matters under advisement and issue written ruling. With that, we will address plaintiff's motion to set aside first. Mr. Thompson, when you're ready.
Okay, I just noticed on the notes here that we also have plaintiff's motion for judicial notice of undisputable facts. Are we going to be looking at that today too?
All right, is that included on the notice? I do see that as well, and I do have those pleadings. So yes, we can take that up as well.
Okay, thank you.
We will take these matters up in the order that they are listed on the hearing notice. So we will take up the motion to set aside, the objection for the attorney fees, and then the notice, judicial notice of undisputable facts.
Great.
Go ahead.
Well, this is kind of round two of this this business, and so we still maintain that the whole anti-SLAPP motion would be replied to a SLAPP lawsuit of some kind, and the lawsuit against Mr. Reinke and all is we just don't see that as a SLAPP lawsuit, because we are not attempting to interfere with anybody's free speech about anything. In fact, this anti-SLAPP motion is actually more of a SLAPP lawsuit in itself than the underlying lawsuit. So, you know, how do you anti-SLAPP an anti-SLAPP? I don't know, but it just seems entirely inappropriate. Going through the ORS 31.150 stuff, they pick these little things out, but nothing has been specific. And by the way, in that anti-SLAPP, they were completely devoid of any kind of declaration or affidavit, which seems to be a requirement under that statute. The anti-SLAPP, Oregon anti-SLAPP statute, I don't think is a very good statute. It just has a lot of problems. And when we look at these things, Mr. Steele has filed at least one that I know of involving a person I know. And in looking at that, Judge Flint granted the anti-SLAPP, and that actually seemed like a legitimate anti-SLAPP situation. But it was overturned in the Court of Appeals. And I haven't gotten a hold of the filings on that to take a closer look. But that was a much more of an anti-SLAPP situation than this is. And so, you know, It's not like to be something that they, there was six, 4, 5, 6, which after of this judgment. How we see that. At the heart of all of this matter here is the of all rights we don't know it, and so this entire effort, property rights, and it has done so. We've been deprived in a major way of our property rights, and that's why we're here fighting for our property rights and for the United States Constitution. And we are facing an unbelievable amount of opposition in that fight. So, so we feel that the judgment should be set aside, and the matter should be more fully dealt with. We also feel that we have made it clear that this isn't a frivolous matter, that there is a huge amount of evidence about what has gone on here, that just can't be brushed aside with an anti-SLAPP motion. And that needs to be more thoroughly examined. And so, without going through all the details of the pleadings, which you've read, that's really all I have to say on that.
All right.
And I'll address whatever Mr. Steele has.
Thank you. Mr. Steele?
Thank you, Your Honor. I'll keep this brief. It's clear to me, listening to the plaintiffs, that what they really are interested in is relitigating the merits of the anti-SLAPP motion. And that issue has been decided by the court. A judgment has been entered. What their motion actually says is that they're moving this court to set it aside on the basis of fraud under ORCP 71B13, and also citing ORCP 71C. But looking at the pleadings themselves and understanding that there is clearly some confusion there, they want to relitigate and allege that underlying their lawsuit is potential fraud by the defendants, but they're not even very clear about that. They just kind of mention about potential representations, but that's a misunderstanding of really the provisions of ORCP 71B-C, which talks about fraud in the context of setting aside a judgment if the court finds that it was procured, meaning the judgment was procured by fraud, meaning some conduct by the adverse party that led to the judgment, which was fraudulent or based upon misrepresentations. They really have not alleged that. They really want to, in their support of their motion, have suggested that there are underlying misrepresentations by the defendant in the underlying case, meaning nothing related to the entry of the judgment, but rather maybe facts or allegations underlying the claims that they have in the lawsuit. But that's not a basis to set aside a judgment under 71. And so our position is that they really haven't established anything for this court to set it aside. And as we pointed out in our motion, even if they were relying upon 71A, which talks about the court using its discretion for clerical errors or omissions, that's very limited situations in which the court has made a mistake, not where the court is given discretion to make adjudicatory kind of findings or to relitigate the case. That's not really what it is. For example, I think one of the cases we cited were situations where maybe a judgment is entered with the wrong numbers. Maybe the court has entered a $75,000 as opposed to $7,500. That's an error or admission. But again, they really have not alleged anything to set it aside either under 71A or 71B. And then with respect to C, I think we've addressed that as well. There really is nothing that they've alleged in there that would give the court a basis to set this aside other than their general arguments that their constitutional rights have been violated, or I apologize, I don't really understand their argument. I think it is that they maybe just don't believe their lawsuit is an anti-SLAPP lawsuit. But as this court might appreciate, really that's never been our position. Our position is the allegations against the defendants arise out of protected speech under that anti-SLAPP statute, and therefore that's the reason it was dismissed. So unless the court has really any other questions, our position simply is that they really have not alleged anything sufficient under 71 to set it aside for the reasons set forth in that statute.
Thank you. I don't have any questions. Mr. Thompson, did you have any response?
Yes, in the pleadings here by Mr. Steele and stuff, there are repeatedly the use of words of presume and intended, as if he knows what we're thinking or something. And that's simply not appropriate because he couldn't even begin to know that. He's just making a lot of presumptions and presenting them as some kind of argument before the court. We also rely on Haynes v. Kerner, which is a Supreme Court ruling about how, the pro se pleadings that aren't held to the same thing, and they have to be given a lot of leeway and to the benefit of the pro se person. That's been through the Supreme Court many times, and so we can't be held to some kind of little rules and things like such as Mr. Steele refers to here. Also, the entire anti-SLAPP thing. He said that we filed an anti-SLAPP lawsuit. No, we didn't. He filed an anti-SLAPP motion to dismiss. So I'm not sure what he's thinking about there. But the other big issue here is that I have a lot of trouble with the constitutionality of the anti-SLAPP motion. I don't believe it's constitutional. In Washington State, they did away with the anti-SLAPP motion and reworked it and call it UPEPA. And it actually makes a lot more sense there now. But I plan on filing a notice of a constitutional challenge to this anti-SLAPP statute. And so we'll let the Attorney General take that and see what they do with it. But it just seems to be subject to so much abuse and denial of serious matters that just get swept away with it, which is really inappropriate. And our property rights have been compromised, and rights aren't something that anyone can take away. They can only be violated, and our rights have been violated for 10 years now.
May I also add, Your Honor, that we did file on April 1st a request for findings of fact and conclusions of law in this as well. So we've been waiting for that.
All right, thank you. All right.
That's all, Your Honor.
Thank you. We will move then to the objection to the statement of attorney fees. I will hear first from Mr. Steele as it relates to the statement, and then I'll hear the objection. Mr. Steele, go ahead.
Thank you, Your Honor. As this court is well aware, we filed a motion under Oregon's anti-SLAPP statute against the lawsuit. It was granted under ORS 31.152, subpart 3. The statute mandates that the court shall award attorney fees and costs to a prevailing defendant when they file an anti-SLAPP. We have prevailed. A judgment was entered indicating that we were the prevailing party. We have filed accordingly a motion for attorney fees, asking the court to an award $9,352.50 and cost and fees of $642.86 in accord with the statute. And that's really all that I have to add to what is already before the court in our our briefing.
All right, thank you. Mr. Thompson, your objection?
Well, we have a copy of this thing. We feel that that the fees are completely unreasonable. There are also a lot of questions relating to the sister suit, if you will, as it's been treated, and the great disparity between those fees and these fees, and looking at other things, even Mr. Steele's fees are excessive and beyond reasonable. One of the issues that I have there is that, as I mentioned, Mr. Steele has filed these things before. You know, he probably has a little, anti-slap app button on his phone that he uses all the time. So to concoct all these fees is pretty crazy. And then we have the whole matter of the collusion with the other party, or they were like doubling up on attorney fee issues here with, conferences with each other and conferences with the PLF and all these things that are quite unrelated to the simple matter of the fees involved in this anti-slap motion. And we'd like to just go through this one too.
Understood.
And what I'll add here before is that there is a considerable amount of Supreme Court precedent where the assigning of attorney fees on pro se litigants is entirely inappropriate. Pro se litigants are, it's pretty much impossible to make claims for attorney fees as a pro se litigant. And so that sets a completely non-level playing field for the whole thing. But
Do you have any authority you want to give to the court on that
yes, I
point?
do.
All right, go ahead.
There's a case, Hughes v. Rowe et al., ROWE. I can't quite make up, I guess it's 449 US 5, this is Supreme Court 1980. And then there's another number down here, number 79-6000, Supreme Court of the United States, decided November 10th, 1980. And it has many more citations in it, within it, that all say the same thing. So to get to the Steele Law Firm itemized description of things here, we have review summons and civil complaint. Okay, that's okay. Okay, and then we have a review of OECI regarding dispute history between Reed's and Thompson's, as well as Thompson's criminal histories. Okay, this is nothing but a disparaging sort of statement to put in here. It makes it sound like we have some kind of massive criminal history. And this is nothing but a smear, an attempt to smear before the court our character, which is vastly superior to anyone that I've seen dealing with this stuff. So again, we have what? What are these criminal histories? That's plural, right? So that can only mean all kinds of contempt things, which nothing has been settled through any of this contempt stuff. And there's no basis to even say anything like that, let alone go digging into it and, oh, look at somebody alleged contempt here, alleged contempt there, when all that contempt refers directly to us standing up for our constitutionally secured property rights. How that's contempt, maybe some people find that contemptuous. I don't, and I never will. And then, let's see, corresponding to Mark Reinecke. And then we have a correspondence to Mark Reinecke regarding, who knows what, for $562.50. So, who's getting what for who? And, this whole game of we got the PLF in here. Is the PLF paid paying these things? Did these fees go to Mr. Reineke? Do they go to the PLF? You know, it's a pretty ugly ball of stuff there. Draft anti-SLAPP motion, 337. Now, you know, from what I've seen of things, that seems reasonable enough. And then letter of representation, and then, okay, draft. So we, on December 18th, we've drafted an anti-SLAPP motion. And then on December 19th, we've drafted another one. So, I mean, which one is it here? We got 337, we got 832.50. And then we got some more correspondence with Mr. Reineke. And then we have another draft anti-SLAPP motion, 6750. I mean, it's like, what's going on here? You know, so that's a lot of drafting. Correspondence, Reineke. Oh, and then we're drafting it again on December 21st. So what's with all this repeated drafting? I don't get it. And then we get into correspondence with Stephanie Kuchera regarding her representation. That seems entirely inappropriate to include in this claim for attorney fees. You know, we already have Ms. Kuchera claiming these exact same things, and I don't think they're legitimate on her behalf either. This is just another way to you know, pad all this billing up. So then we have those. Then we have review and send anti-SLAPP motion to clients for review. Now this step gets a little bit interesting. This was on day after Christmas. So we have a word that we have a couple of words that get interspersed through here without really any clarity on what they are. And I can only assume that when Mr. Steele uses the word clients, that he's referring to the professional liability fund, although he could maybe clarify that. And then we have the other word that he uses from time to time is dependents. So I would assume that means Mr. Reineke and BLJ Law Firm. But again, we'll get some clarification on that, I guess. And then we have more correspondence with Mark Reineke attaching revisions to the anti-SLAPP. Again, I don't, as an anti-SLAPP, you know, filed in this thing when the client is the PLF, I don't really, I could see some communication with Mr. Reineke, but that doesn't really seem to be something that should fall under attorney fees for these claims. Then we have some more correspondence from Stephanie Kuchera regarding that. That's really relatively small, but and then we have revised motion to strike to incorporate changes from clients, send back to clients. Again, we could probably use a little more detail on that, like what is this motion to strike that he's talking about here? Research requirements to prosecute claim, ORS 31.3. So again, this is ludicrous. He's researching the requirements to prosecute a claim under this. Mr. Steele's an experienced attorney. He's been practicing this stuff for some time. So he's got to go out and do research on this kind of thing. It's absolutely ridiculous. Corresponds to claims. And then revise and finalize anti-SLAPP motion and send final version to clients, assuming PLF, but who knows. So we're, not only have we drafted and redrafted and drafted this thing about 5 or 6 times by now, we're going to throw some more revising and finalizing in there. The redundancy is off the chart with this stuff. Then we have correspondence from Stephanie Kuchera regarding anti-SLAPP motion. I mean, why are we corresponding with Ms. Kuchera regarding all this stuff? Correspondence with to Ron Thompson regarding his motion to strike in response. Okay. Correspondence to client, we have again here, forwarding emails. Notice from the court regarding signed document. Okay, I'm not sure what that even means, but we got 2250 worth in there. I'm sure that's kind of a little minimal tick on the bill that we do, but what notice regarding signing of what, I have no idea. And then we have, again, getting into this review OECI with respect to dates of filings of pleading and review motion to disqualify and order. Again, who knows what that's about? Does that have anything to do with any of this? It doesn't really say. Next, January 16th, receive and review defendants Lisa Andratch's special motion to strike and motion to consolidate. Okay, so what's that doing in here? That's, to me, is nothing but more and more signs of collusion and conspiracy, and just blatant in your face conspiracy, which to me discredits this entire business of these anti-slaps. Correspondence to clients attaching defendants Lisa Andratch's special motion to strike and motion to consolidate. So here, I mean, even that, what that's doing an attorney fee bill, I have no idea. I think it's inappropriate. And what is Mr. Steele doing, claiming a fee for corresponding with his clients, which I assume to be the PLF, and attaching this stuff? I mean, the PLF is involved there too. So we're like doing all this double back and forth kind of crisscrossing here and there and stuff that can only confuse a billing situation, which is entirely inappropriate anyway. Okay. January 25th, review response to anti-slap motion. Draft reply to objection. I'm trying to see some reasonable aspect to this. And that would have been before, I guess it was, the matter was heard. So, okay, receive and review Andratch's reply to special motion to strike, forward to client. So we have Andratch's reply, which is that's a kind of strange thing to call it, and it also brings up another question in my mind that Mr. Steele here and Lisa Andratch have quite a history working together on various things. She had a matter from other questionable activity that took her all the way to the Supreme Court over her being barred from the Oregon State Bar, which only the bar could have done that. And somehow, through some kind of magic, Mr. Steele managed to salvage her bar license and get that matter from the Supreme Court, which is quite questionable. So anyway, there's a noted relationship between Lisa Andratch and Nathan Steele, and all this back and forth stuff. The more they do this, play this game back and forth. Okay, you do this, you do this. I'm gonna add this in our bill. You can add this in our bill, and we'll just rotate this stuff around, and we'll just ding along here because there's one objective in all of this, and I'll get to that at the end. Correspondence from court regarding details of hearing, forward to client at January 31. Correspondence from Stephanie Kuchera regarding court hearing. Okay, that doesn't belong in here. Correspondence from Mark Reineke regarding a blank. February 4th, prepare for hearing, review all pleadings and related statutes and cases, So Mr. Sue is going to put out $765 for this thing. Okay, again, he already knows what the platings are. He's going to go review them again. I need to review that again. And the statutes and everything. This isn't, again, I don't know just how many, but I know that Mr. Steele has filed other anti-SLAPP, motions. And so, I don't know if he's forgetful or what, or things have changed. I don't think they have. So how do you go back and, oh yeah, I think I'm going to review this one more time, and because is he uncertain about what he's doing, or has he never had a rodeo like this before? I don't know. Again, I have to question that. And then we have some correspondence with Mark Reinecke, February 5th. Continue preparing for hearing, outline oral argument. And here we got 652. Attend the hearing, $720. 3.20 hours. Was it that long? I don't know. Might have been. But, okay, he did attend the hearing, along with Stephanie Kuchera. And so, receive and review Thompson's supplemental substantial evidence, okay? Correspondence to clients attaching supplemental pleading.
It says right there, we have substantial evidence.
Yeah. I mean, the substantial evidence is off the chart, and there's more of it every single day. We continue to be harassed and threatened every single day coming and going to our own home. We have been, driven down. We've had interference. My wife's had to lose her job or a couple of jobs because of these people and all this stuff. We had over $500,000 arson attack on our property. None of these things would be happening without all this. So anyway, where am I here? Court's written decision. He's going to charge $45 just to receive and review the court's written decision. Draft order of general judgment of dismissal. Yeah, just to draft that thing up to a resume. Okay. Review file regarding complaint and motion caption and moving party. Again, not really clear what that might mean. Review ORCP 23 with respect to amending by interlineation. Right. Again, don't know what that really means. Correspondence to client. PLF. Attaching notice of corrected caption and explaining the basis of the notice. Now, all this caption thing, I think what he's talking about there is that, as these companies change, they change their little, things from LLCs to PCs and stuff like that. So anyway, that doesn't have anything to do with me or us or anything. Correspondence surrounding the proposed order on special motion to strike. Again, I'm not sure what that was. What are we doing there? Check OECI regarding order of entry. Oh, we got to look at that, a little click on the computer. And we're checking OECI again. Revise order, correspondence. Okay, these are all those little clerical kind of stuffs, and it's hard to tell. We have NGS over here, but anybody could do that. March 22nd, telephone conference with Stephanie Kuchera regarding additional motions. Again, I'm not sure what those are. Correspondence with Stephanie Kuchera regarding status of the case. Now, this is completely after the fact. So how anything after the fact can be included in this stuff is beyond me. It's just a big scam here. Correspondence with Stephanie Kuchera regarding communication with Ron Thompson. Now, correspondence to client regarding Thompson settlement offer to Stephanie Kuchera. Again, all of this stuff, this didn't have anything to do with Stephanie Kuchera. I don't know where this stuff's coming up with. We dealt exclusively with Erica Wilson on this stuff, not Stephanie Kuchera. So Erica Wilson is the one who, promulgated this ridiculous settlement offer, as we've seen, and we countered that offer, and so attaching Thompson's settlement offer to Kuchera, that was a counter to the agreement, and but it doesn't really say that here, and so what that has to do with Mr. Steele, in this case, I have no idea, because that wasn't part of this, except for the communication that they had about it, which only proves further collusion and conspiracy in all this matter. Prepare outline or motion to set aside, highlight matter warranting response. Again, we're charging for things from here on that are entirely after the fact of the judgment. And so they have no business being part of this attorney fee stuff here. No judgment, check out OECI regarding entry of general judgment review. We just got to keep checking this OEJI on this one, not OECI, just to keep, dinging our little bell here. Draft defendant's response to plaintiff's motion to set aside. Again, that's entirely after the judgment. So it has no business in this bill at all, if anything does. Finalize defendant's response to plaintiff's motion to set aside. Again, all this stuff is entirely after the judgment was made. 100% revised and finalized fee petition for declaration. Again, there we're revising and finalizing, including a bunch of stuff that is entirely after the fact. So I think we've covered that.
Thank you. Mr. Steele, any response?
No, Your Honor, I have nothing to add unless the court has any questions.
All right. Thank you. We will proceed to the third matter before the court. Plaintiff's motion for judicial notice of undisputable facts. Go ahead, Mr. Thompson.
Okay. Make sure I'm looking at the right stuff here. Yes, we filed this motion for undisputable facts in support of the motion to set aside, and basically throughout all of the last 10 or 12 or whatever years, there's been an absolute refusal of any party to even bring up the matter of the deeds, which are the basis for the property rights. And the deeds are very clear. And so we included as exhibits the original deeds and the present recorded deeds, and then also the latest version of the Serbian property deed, which indicates the alteration of the wording in it. And so I don't know what these are all documents that are in the court clerk's office recorded. They're unquestionable. There's nothing about them that that has changed or can be changed.
You're self-authenticating.
Yeah, my wife here has mentioned that these are in fact they're all stamped by the court clerk clearly, and they are in fact self-authenticating. They stand on their own. So Mr. Steele here has made some kind of weird comments about handwriting on them and stuff. There's none of that. I don't know where he's getting that stuff, but I guess we'll let him explain that.
All right, thank you. Mr. Steele?
Thank you, Your Honor. Just a couple quick points on that. First of all, under ORS 40.060, normally courts may take judicial notice of adjudicated facts that are at issue between the parties that may later come into play with respect to an adjudication of the case. Our position is that this motion is untimely by virtue of the fact that the case has already been adjudicated and a general judgment has been entered. And so in that respect, at this point, there's nothing to adjudicate, and therefore there are no facts to be admitted that could be adjudicated. And so we believe it's untimely. We also believe it's improper in the sense that, as we've noted in our briefing, adjudicated facts as defined by Oregon laws are those facts with a high degree of indisputability. The documents attached are not, contrary to what plaintiffs are arguing, are not self-authenticating simply by merely the court putting a stamp on it by them being filed in other proceedings. They're not self-authenticating, and there's been no proper foundation for them. And quite frankly, we question some of the accuracy of those documents, or at least we dispute the documents. And in that sense, they're not ones that could be adjudicated by the court. I also expressed some concern, I think, with respect to whether because of the appeal, the court could rule on it. But I do believe, I've kind of gone back and forth about this. And just to be clear what I'm talking about, by virtue of the filing of the notice, obviously the court can consider while a notice of appeal or after a notice of appeal has been filed, can resolve a motion to set aside under 71. But I think this is part of that. And therefore, I don't think we have a problem with the court ruling. I just wanted to raise that because it concerned me. Because I wasn't quite sure if the court could rule on that motion, because it's not really an ORCP 71 motion, which the court could rule on. Also, the court still has jurisdiction over requests for attorney fees when there's been a filing of an appeal. I guess the best that I can say is that it's related to the ORCP 71 motion, although it's separate. I'm kind of thinking out loud, Your Honor. I just wanted to raise that to the court because I thought about it and I wasn't sure. But I guess what I'll say to the court is maybe it's not something the court can rule on. I'll just raise that. I think it seems like a separate motion than the ORCP 71 motion, but if the court finds it separate, then I don't think the court could rule on that anyway, because the court has lost jurisdiction by virtue of the filing of the notice of appeal. If it's instrumental and I guess related to the ORCP 71 motion, it's almost like a supplemental or corollary component of that, then I think the court rule on it. But for the reasons we've already stated, we believe that it should be denied as untimely and improper. But I at least wanted to raise that because I think it's kind of a little quirky issue that I'm sure this court has thought about. But in the event that the court doesn't find that it's actually a part of the ORCP 71 motion, then I think the court would have to not rule on that by virtue of the fact that at this point jurisdiction resides with the Court of Appeals other than the ORCP 71 motion and the request for attorney fees. So other than that,
Mr. Steele,
oh, sorry, Your Honor, go ahead.
I'm sorry to interrupt. Would the same logic apply to the April 4th filing of the request for findings of fact and conclusions of law? I mean, that was filed after the court entered written opinion.
Yeah, that's right, Your Honor. I mean, obviously, the timing of that, I think the rule requires at least a request before it's untimely. But I think technically, Your Honor, I think the logic would follow that it's not one of those exceptions to the general jurisdiction rule. So I guess I would have to err on the side of caution and say that that's probably one that the court doesn't have jurisdiction over, because it just doesn't fall under one of the exceptions. So I think you're right, Your Honor.
All right. That was the only question I had. I cut you off. Anything further, Mr. Steele?
No, thank you, Your Honor. Unless the court has any other questions, I have nothing more to add than what we've already stated in our pleadings.
All right. Mr. Thompson, anything to add?
Yes.
Go
The,
ahead.
These deeds and also are something that that everyone seems to get a little bit panicky when they're brought up because they have never been addressed. There has, as you know, there was a declaratory judgment issue that revolves all around this, but nobody wants to talk about it because you know what? It doesn't work for them at all. The deeds stand on their own. They identify the property, the ownership, and the rights to the properties involved. It's in RAM. It's not personal jurisdiction. It's property. The rights that are assigned to and agreed to, by the contract of the deed that define everything. And it's a far cry from what's going on now. And so until that is fairly dealt with, there's just going to continue to be problems. And so at some point, this filing, we're filing these in everything, and we'll continue to until it is dealt with. But, they're just the games played around avoiding dealing with the deeds and what they say and the law related to the deeds is the essence of all of this stuff that's gone on for 10 years. So,
All right.
that's all I'm saying.
All right. Thank you. As indicated, the court will take the matter under advisement and issue written ruling. All right. Thank you. Court will be in recess.
Thank you, Your Honor. Have a nice day.
You too.